When people review a SaaS contract quickly, they often focus on limitation of liability, pricing, data protection, or intellectual property. That makes sense. But one clause is still consistently underestimated: termination. And that is a mistake. Because a weak termination clause does not just create legal uncertainty, it creates operational risk, revenue risk, negotiation imbalance, and sometimes a very expensive exit. So in this video, I want to show you 3 red flags I would catch immediately when reviewing a termination clause in a SaaS contract. So, let's assume the clause says something like this. Either party may terminate this agreement for material breach. The customer may terminate for convenience upon 30 days notice. Upon termination, access to the services will cease. Provider will delete customer data in accordance with its standard practices. At first glance, this may look acceptable. It is not necessarily catastrophic, but it contains several issues that deserve immediate attention. Red flag number 1: termination for convenience is asymmetrical. The first red flag is asymmetry in termination for convenience. If one party can walk away without cause and the other party cannot, that is not just a drafting detail, that is a leverage issue. Here, the customer can terminate for convenience upon 30 days notice. So the first question is obvious: can the provider do the same? If the answer is no, then the allocation of flexibility is one-sided. No, sometimes that asymmetry is commercially justified. For example, in a customer-friendly paper, or where the supplier is pushing a standard form at scale, the parties may deliberately accept different exit rights. But you still need to test the actual business effect. Ask: is there a fixed subscription commitment? Is any prepaid amount refundable or non-refundable? Can the customer exit before the initial term ends? Does the provider rely on implementation cost being recovered over time? Is there any minimum revenue assumption built into the pricing? Because the real issue is not simply whether termination for convenience exists. The real issue is whether the contract allows one side to destroy deal predictability without paying for that flexibility. So if I see this kind of clause, I am not only marking the exit right, I am checking the economics around it. A more balanced position may look like this. The customer may terminate for convenience only at renewal or upon a defined notice period, provided that fees for the committed term remain due. Or, alternatively, either party may terminate for convenience after the initial term upon not less than 90 days prior written notice. The point is simple. If there are convenience terminations, it should be consciously priced, limited, or balanced. It should never sit in the clause as if it were neutral boilerplate. The second red flag is a vague breach language combined with no real cure mechanism. The clause says either party may terminate for material breach. Fine, that is common, but what does material breach mean here? And what happens before termination actually takes effect? If the contract does not answer those questions with enough precision, the clause becomes a conflict trigger. Why? because in practice, parties rarely agree in real time on whether a breach is truly material. One side says the failure was serious, the other says it was minor, temporary, disputed, or already being corrected. So I immediately checked for three things. First, is there a cure period? For example, 30 days after notice of breach. Second, does the cure period apply to all breaches or only some of them? Third, are some categories of breach carved out for immediate termination, such as non-payment, confidentiality violations, sanctions issues, or repeated security failures? Without that structure, the clause gives the appearance of discipline while preserving a lot of ambiguity. A better version usually looks more like this. Either party may terminate this agreement for a material breach by the other party if such breach remains uncured for 30 days following written notice describing the breach in reasonable detail. That is already much better. Why? Because it forces sequence: notice first, opportunity to cure second, termination third. And if you want to go further, you can distinguish between curable and incurable breaches. For example, either party may terminate immediately for a breach that by its nature is not capable of cure, including a material breach of confidentiality or unlawful use of the services. That structure is far more operational. It reduces opportunistic termination arguments. It also makes internal advice easier because you can tell the business team not only whether termination is theoretically available, but whether the procedural steps have actually been satisfied. So, this is the takeaway. Whenever you see material breach, do not stop at the label. Check the mechanism. If the mechanism is weak, the right itself is unstable. So, the third red flag is the most underestimated one. The clause tells you that access to the services will cease and that customer data will be deleted in accordance with standard practices. That is not enough. In many SaaS contracts, the real risk is not the legal act of termination, it is the operational transition that follows. If the contract does not define the post-termination mechanics, the exit may become disorderly, expensive, or strategically painful. So I would immediately ask, does the customer get a data export right? In what format? Within what time frame? Is there a post-termination access window? Is transition assistance available? Is that assistance included or separately charged? When exactly must deletion occur? Can deletion be suspended for legal retention purposes? Which clauses survive termination? This matters a lot because provider will delete customer data in accordance with its standard practices, is supplier friendly but operationally incomplete. It puts the critical offboarding mechanics outside the contract, often inside internal practice, support policy, or informal discussion. That is not where you want core exit rights to live. Here, a more useful formulation may look like this. Upon termination or expiration, customer shall have 30 days to request export of customer data in a commonly used machine readable format. During that period, provider shall provide reasonable access to the data solely for retrieval purposes. Following that period, provider shall delete customer data, except to the extent retention is required by applicable law. That version is better because it answers real business questions. And depending on the deal, you may also want a transition assistance provision, especially for enterprise implementations, regulated customers, or business critical software. For example, at customer's written request, provider shall provide reasonable transition assistance for up to 60 days after termination at provider's then current professional services rates. Now, the offboarding process is at least visible, structured, and negotiable. That is a major improvement over a clause that simply says access ends and data gets deleted somehow. So, if I had to reduce this to a fast review checklist, it will be this. When you read a termination clause in a SaaS contract, check 3 things immediately. 1. Is termination for convenience balanced, limited, or economically priced? 2. Is material breach tied to a real cure process, or it is just vague language waiting to become a dispute? 3. Does the contract explain the operational consequences of termination, especially data export, deletion, and transition support? If those 3 points are weak, the clause is not finished. Even if it looks standard, even if everyone in the deal is calling it boilerplate.